Welcome back for lunch. Hopefully this topic won't put everybody to sleep after you got your tummies full, all that kind of fun stuff. But yes, so we'll be speaking for the next hour, I guess, on matters related to Title IX. And in full disclosure, I was hoping to have a completely different presentation for y'all today on this, because you probably heard that Department of Ed well over a year ago issued proposed rule updates on Title IX, and their published schedule for when they were hoping to have all of the final rules sent out and published so we could get ready. Department of Ed was supposed to get everything out to us in May, what the final rule was actually going to be. Well, we are now several weeks past May, and we don't have the new final rules. So again, I was hoping to be able to come here today and tell you exactly what Title IX is going to look like moving forward, but Department of Ed is running behind, and so we are going to talk more about the current Title IX rubric, what we should be doing, but just be aware that this is all subject to change in the next coming months whenever Department of Ed actually does issue their final rules, or the updated final rules. We kind of think we know where we're going on this. The proposed updates were very substantial, lots of changes. We don't know what the final rule is going to look like, though, because there were nearly 250,000 public comments submitted on the proposed updates, which was more than double the number of public comments that were received the last time Title IX was updated back in 2019, 2020. And so we know Department of Ed has their hands full trying to go through and figure all that stuff out. So I guess a very long-winded way of my saying that we're now going to talk about Title IX as it currently stands. I remind you all what we need to be doing as this new school year starts. Fingers crossed, hopefully Department of Ed isn't going to release their new updated rules like in July or August, right when school starts, and say, congratulations, you have to start implementing this stuff now because that's going to be major policy updates, all that kind of fun stuff. But we'll just kind of wait and see what our overlords in DC decide to do when it comes to Title IX. So, all right. What is Title IX? Well, it's a federal law. It applies to any recipient of federal funds. We know that as public schools, we do kind of need those federal dollars. And with all things federal, there are always going to be strings attached. And one of those strings when it comes to receiving federal funds is that we are required to comply with Title IX. And Title IX is a federal civil rights law that tells us we cannot discriminate on the basis of sex and how we operate our education programs or activities. We know for the most part, Title IX is usually considered in athletics and college athletics, where we have to be sure that we don't have, well, we know that in athletics, it seems like at least in Texas, football programs have the bajillion dollar budgets, and other sports get not so much, but that's, Title IX is designed to prevent that from happening, to make sure that our male and female students are treated equally when it comes to access to our education programs or activities or anything else that we're doing. So that is the basic impetus of Title IX, is to make sure that we are not discriminating on the basis of sex, that we are treating our male and female students equally when it comes to their ability to enroll in our schools and then to participate in our school activities. Department of Ed is interpreting Title IX, this discrimination based on sex, to also include LGBTQ status, or not discriminating against students who happen to have a different gender identity than their gender or sex assigned at birth, or things like that. So that is where Department of Ed is headed, and the new Title IX regulations, whenever those are finalized and published, it's going to be very clear that yes, discrimination based on sex means discrimination based on LGBTQ status, or gender identity, gender expression, things like that. We're gearing up for lawsuits on that here in Texas, because we know that our state, our governor, and our attorney general are already, I'm sure they're ready, willing, and able to go ahead and file lawsuits in the event that that becomes the federal guidance. They've been ruminating about that ever since these new proposed updates came into play. So we're going to have a major conflict, at least in Texas, on how the federal government wants us to interpret discrimination based on sex and how our state officials are going to be considering that term, unless something really crazy happens in Austin and our state leadership decides to kind of change course there, but I'm not thinking that's going to be happening. Okay. So when we're talking about discrimination based on sex under Title IX, what we're really looking for, or what the government, what OCR is going to be looking at if they receive complaints, is do we have an environment where we have conduct that is so persistent, or so severe, pervasive, or substantively offensive, that it creates a hostile environment, or that it denies people the opportunity to have a healthy or a safe educational environment. Okay, so sexual harassment, type may be a little bit small, but there's essentially 3 different types of sexual harassment under the Title IX regulations. The first one is going to be quid pro quo harassment. That means if we have a scenario where a school employee is conditioning some sort of aid or benefit of the school on someone's participation in some sort of sexual activity. So, I have a teacher who tells a student, you're not going to get an A in my class unless you do X, Y, or Z with me. Or a supervisor who says, you're not going to become a grade team lead unless you do X, Y, or Z with me, those type of things. So that's going to be quid pro quo harassment. That is prohibited by Title IX. The second type of prohibited sexual harassment under Title IX is hostile environment. I think we know what that is for the most part. Just if we have a scenario where someone does not feel safe or does not feel comfortable in our school environment because the supervisors are always catcalling them or trying to touch you on parts of your body you don't want to be touched all the time, or if there's inappropriate pictures being sent or text messages or being passed around the office, things like that, or if a student is consistently, people are consistently talking about their body in a particular way or making comments about their body, that type of hostile environment based on sex. So that's another form of prohibited harassment under Title IX. And then finally, we have conduct that meets the definition of some penal provisions under federal law. And so we have conduct that reaches the level of a sexual assault, of dating violence, of domestic violence, or stalking. Any type of conduct that could fall under those particular types of offenses, that is also prohibited under Title IX. Now, the fun part about Title IX as it presently stands is that the Title IX process only occurs if these prohibited harassment occurs against a person in the United States. The term education program activity is defined very broadly. I think I talk about that here in just a second. Yes, this particular slide here. Again, Title IX applies to any programs or any activities that the school operates. That includes, of course, our day-to-day classroom instruction. That excludes field trips or field lessons. If we have athletic teams, while students are participating in those activities, if we have, band trips, choir trips, whatever it is. So anything that's a school-sponsored or school-related event, that is going to be considered part of our educational programs or activities, so long as that particular activity occurs or takes place in the United States. So technically, we could have scenarios where if you give your children or your students the opportunity to, let's say you're going to go to Spain and do a language immersion class over the summer, or you're going to go to Mexico or Italy, whatever, go to China, and you're going to give students a chance to go there as part of a school activity. You send school staff there to be chaperones, and in that particular international activity, a student or a staff member comes back and says, I was sexually harassed while I was there. This teacher or another student did whatever inappropriate stuff to me. Well, that's not going to be covered by Title IX because Title IX only applies to acts of harassment that occur against a person in the United States. I'm not sure why they did that, but that's how Department of Ed decided to do it. I believe that differentiation is going to go away in the new rules where it's going to be, it doesn't matter where the harassment takes place. It doesn't have to be just in the U.S. But again, it needs to be something that occurs against a person in the United States. Now, if we do happen to have an activity that's occurring overseas or in another country, and something bad happens there, that doesn't mean that we ignore it, that we don't do anything about it. It just means that we would not follow the Title IX process for that particular event. So we still have our other standard non-discrimination or anti-harassment policies in place. We still have bullying, we still have David's Law, we still have our codes of conduct for our students and our codes of conduct for our staff, and those will still absolutely apply even if we have harassment or inappropriate conduct occurring outside the US. It's just that for purposes of Title IX, that is only going to apply for harassment against a person in the United States. All right, so what are your obligations under Title IX? Well, the first thing we need to do is designate at least one individual to be a Title IX coordinator. The law or the regulations state one. We know that many schools will decide, or especially larger systems, will have more than one coordinator. Perhaps you will have one coordinator to handle student issues and another coordinator to handle personnel issues. That's going to be a matter for your local schools and what you decide to do. Just the legal threshold is we must designate at least one individual to be a coordinator, and that individual, as a coordinator, is responsible for coordinating our response to reports of sexual harassment and making sure that we are complying with the Title IX process. We also need to have a system set up where we will receive complaints, or we have mechanisms where people can report possible sexual harassment. We know that y'all have your grievance procedures, you have anything, so I think for the most part, y'all have your procedures in place for receiving complaints or reports. We just have to be sure that we don't set restrictions or too many restrictions on when we will receive reports. We have to accept reports in written format, by email, in person, by fax, whatever it is. We also can't put timelines or, I don't know if time's the right word, but we can't set like deadlines and say that all reports of harassment must be received between the hours of 10 a.m. and 11 a.m. only on the third Wednesday of every month. Like, we can't do that. We can't say that office hours are only open during these particular times. We need to accept these reports or allow reports to be submitted at any time and through any method that the individual submitting the report wants to submit. Let's see. We also need to be sure that we have protocols in place where if someone does come to us, perhaps someone comes to a teacher, a student says, hey, my classmate has been touching me in a private area or an intimate area, I don't like this. Well, our staff need to understand that they should be going to our Title IX coordinator, referring it to that, because we need to make sure that our Title IX coordinator is made aware of these situations as soon as they come up. And we'll talk about more about why that's important here in a few slides. And I guess I should potentially say the next slide, because again, once we get these reports that come in, our Title IX coordinator has an obligation to kind of do an initial assessment of the report or of the case. And this is where we kind of see some hiccups when we're asked to review scenarios like this. We know that for the most part, y'all as campus leadership or as principals, when you get reports, you are very good, very diligent about starting your investigations right away and doing your best to find what happened as soon as you can so that you can make a quick and prompt and appropriate decision about what any consequences may be. But we need to be careful in Title IX because there's language in the Title IX regulations saying that we are kind of restricted in the scenarios where we can actually take disciplinary action against someone for potential sexual harassment. And there are a lot of rights and a lot of procedures that need to be put into place, or that need to happen before we can actually take that final disciplinary action. And so when it comes to sexual harassment, if you're a campus leader, again, we know your first impulse is to get right in there, do your investigation, make your findings, and then assess consequences as appropriate. But when it comes to Title IX, when you're sexual harassment or possible harassment, you need to kind of slow your roll just a little bit, go to your Title IX coordinator first, and then let the Title IX coordinator kind of guide which direction we're going to go. So if we get reports of something that could possibly be sexual harassment, we need to be going to our Title IX coordinator. Our Title IX coordinator then kind of does this initial assessment to see, okay, well, if these allegations or if these reports are true, would this particular conduct fall in the definition of sexual harassment under Title IX? So do we have quid pro quo harassment? Do we have a hostile environment? Or do we have the dating violence, the sexual assault, the stalking, or the domestic violence? And if the Title IX coordinator answers yes to any of those questions, then we kind of get to go through the more detailed, or at least offer this more detailed Title IX investigative process. If the Title IX coordinator looks at everything and says, well, no, this isn't anything that's covered by Title IX, then y'all can usually jump right back in and do your normal prompt investigation and kind of handle things as you normally would under your code of conduct. All right, so again, the initial assessment by the Title IX coordinator. If true, does this conduct meet the definition of sexual harassment under Title IX? Did it occur within our education program activity? So again, was this something that happened during a school event, or was this students DMing each other stuff on a Saturday night when they're not at a school activity? Did it happen during class, whatever the case may be? And then finally, did it occur against a person in the United States? And so if the coordinator says yes to those questions or can check the boxes for those, then we proceed under Title IX. On this particular slide, I'll just mention that again, even if we get a report and if our Title IX coordinator decides at the front that this does not meet the definition of sexual harassment, or it didn't occur in our school program activity, or it didn't occur against a person in the United States, that doesn't mean we drop it and we do nothing. Again, we still have an obligation to investigate or consider any reports of violations of our code of conduct. And so even if something doesn't fall under Title IX, we still follow our standard protocols for responding to those type of reports and doing an appropriate investigation as necessary, and then taking any corrective actions or remedial actions if we find out that some sort of code of conduct standard was violated. So we never want to bury our heads in the sand. That's the absolute worst thing we can do. If there is a report of possible harassment, again, even if it's not Title IX and a parent decides to go to OCR, well, the first thing they're going to ask is, what's your investigation? What did you do? And if you did nothing, they're going to most likely find that you acted with deliberate indifference, which means congratulations, you're going to have all sorts of penalties put on you by OCR. And that can also lead to, if there's civil litigation following OCR, or if a parent files a lawsuit claiming discrimination and a court finds deliberate indifference, congratulations, there goes your budget for the year. Because the school's going to be on the hook for potential liability for violating someone's civil rights. So again, don't ignore complaints. That is the absolute worst thing we can do. Okay. If the coordinator reviews the report that comes in and checks all those boxes that, yes, this conduct, if true, meets the definition of sexual harassment, yes, it happened in our school program or activity, and yes, it happened against a person in the United States, well, at that point, our Title IX coordinator has an obligation to go ahead and reach out to the complainant. The complainant is the potential victim or the person who was possibly harassed. And our coordinator needs to reach out to that person and talk about potential supportive measures, which are things that we can do to help that individual essentially feel safe or make sure that they are not continuing to feel harassed while they're at school. There's no set list of what a supportive measure has to be in every circumstance. That really is up to y'all for each individual circumstance. For students, maybe we have a student where we think it's best to have someone escort them during transitions from class to class. Like, we want to minimize the chance of somebody doing something between classes in the hallway, and so we're going to have a staff member walk them between classes, or we're going to change seating assignments, or we're going to make classroom schedule changes where we change schedules so that these two particular students aren't in the same class anymore. If we have reported employee harassment, we can do the same type of things. Maybe we just switch duties around so that you're not both covering lunch duty at the same time or in the same area. Or, we're going to change a supervisory reporting system or something like that for a short time we investigate so that we don't have those continued interactions. So again, the supportive measures, that's really a matter of local discretion. Y'all can decide what you need to do in order to help the individual who may have been harassed feel safe while we are going through our investigation process. We also need, at that point, the coordinator kind of walks the complainant through our formal complaint process, which we'll talk more about later, but that formal complaint process is incredibly thorough. This is our normal investigation on steroids times 10 for the most part. It is a very, very, very thorough process. The regulations require it to be very thorough, and it does not look like any other investigation we typically do in a school setting. It is much more involved. We are much more open. It is much more of an open book. We are going to be sharing information with both parties. We're going to be letting people know witnesses. We're going to be letting people know names, all that kind of fun stuff. And so it's going to be very much an open book as we go through that formal complaint process. We walk the complainant through that and ask if they want to go ahead and proceed with that by filing a formal complaint. And so we kind of go from there. So this is essentially what, or at least the initial obligations that our Title IX coordinator has. And this is why it's so important for your staff to understand and know who our Title IX coordinator is, so that if they happen to receive a report of possible sexual harassment, they know who to contact so that we can start this process in a timely fashion and make sure that we're not opening the school up to exposure for claims that we violated Title IX, which, as I mentioned, that can get very expensive if it winds up in litigation, because the courts will award monetary damages if we mess up Title IX. Okay. When it comes to talking with the complainant, again, the options are to explain this formal complaint process, which is very thorough. We ask them if they want to proceed in that route. Sometimes the complainant will look at that and say, no, this is too heavy, it's too involved, I don't want to go through this whole rigmarole, it's too much, I don't want to share or have all this information shared with the person who might have harassed me. And so they decide, no, we're not going to go the formal complaint route. Well, we have the ability, we can accept that and decide not to go down the formal complaint route. The only potential issue with that can be that if we do not go the formal complaint route, as I mentioned earlier, the regulations tell us that we should not be imposing discipline against a respondent or the person who's accused of engaging in sexual harassment unless we have completed the formal complaint process. And so if a complainant or a possible victim tells us, nope, I don't want to go through this big, huge Title IX formal complaint process, just handle it by some other way, some other investigation, just be aware that if we do that through a non-Title IX process and we end up terminating someone or expelling someone for conduct meeting the definition of sexual harassment, we could be opening ourselves up for a Title IX claim by that person that was terminated or expelled. And if they did not receive all the procedural rights they were due under Title IX, well, there could be potential liability there. And so it really is a very fine line, a real tightrope we have to walk when we make these decisions as to whether or not we're going to proceed with that formal complaint process. If a complainant says, no, I do not want to do this formal complaint process, our Title IX coordinators still have the discretion or the ability to go ahead and start the process on their own, even over the objections of the complainant. So that's still an option in some ways. Sometimes we see that happen if we have multiple reports. Perhaps we have 3 teachers who all come to us and say that their one particular supervisor or their principal has been harassing them. Well, if we have a possible serial harasser, we may want to go ahead and start that formal complaint process, even if the teachers don't really want to do it. Or if we have reports that, a student has possibly sexually assaulted a peer at school. Well, that could be another situation where that's very serious conduct, and we decide it's worth it for us to go ahead and start that Title IX process on our own, even if the complainant doesn't want to go that route. So there is discretion there. But again, please, if you get into situations where a complainant says, no, I don't want to do the formal complaint process, just tread very carefully about how you handle that and what we end up doing to the respondent. Sometimes if that happens, we will usually try to see if we can find something else, like another code of conduct violation. Perhaps as a student, if there was inappropriate touching, we can say, well, that's assault. You touched somebody inappropriately. And maybe we have more wiggle room there where we can say that, yes, you violated our prohibitions against assault, and so we're going to take disciplinary action for that. I would just say that we normally would not include, if we're going to have an expulsion hearing or if we're going to terminate somebody, we would not say we are expelling you for sexual harassment or we are terminating you for sexual harassment, because if we put that stuff in writing and we didn't go through the formal complaint process, we could be opening ourselves up to a Title IX claim by the person that was fired or expelled, if that makes sense. So it's a mess. And again, kind of runs contrary to what we normally do. So again, be very, very, very careful as far as that goes. Okay. So our coordinator goes through, has that discussion, and if the complainant decides to go the formal complaint route, well, what's a formal complaint? It's essentially a written complaint. So it is something in writing that lays out the details of how that individual feels that they were harassed. That particular complaint has to include facts that show us that at the time the harassment occurred, the complainant was participating in one of our education programs or activities. And we also need to be able to demonstrate or be able to glean from that the person was in the United States at the time the conduct occurred. That formal complaint will be submitted to our Title IX coordinator. Again, that can be in person, in writing, by mail, by email, by fax, by whatever it is. However that person gets us that written complaint or gets that written complaint to our Title IX coordinator. What if the complainant is a minor? So, again, we've got kids, 5th or 6th graders, and somebody claims sexual harassment. Well, we don't have to have that 5th or that 6th grader be the one who signs that formal complaint. A parent has the right to do that on behalf of the child, of course. And so, yes, a parent can file a formal complaint of sexual harassment. It's just the way that we can consider that complaint. The parent is never considered the complainant in that circumstance. The complainant is always the person who was possibly harassed or the potential victim, for lack of a better phrase there. So even if a parent signs off on the complaint, the parent is not the complainant. That's still the child or the person who was actually harassed. And as I mentioned, our Title IX coordinator does have the discretion in some instances to file a formal complaint on his or her own. In those circumstances, the Title IX coordinator is not the complainant. That is still going to be the person that we believe was possibly harassed. I already talked about this, the formal complaints by the coordinator. If we got multiple reports against the same person, or if there's a health or safety issue, we can go ahead and proceed with a formal complaint if the coordinator believes that's appropriate. Now, let's say we get a formal complaint. There are some circumstances where the regulations tell us it's a mandatory dismissal of a complaint. So if we can look at that formal complaint, we read through it, our coordinator looks at it, and the coordinator says, okay, well, based on what's written here in this document, this conduct does not meet the definition of sexual harassment under Title IX. If the written report of that conduct does not meet that definition of sexual harassment, we can dismiss the complaint under Title IX. Or actually, we have to dismiss the complaint under Title IX. Again, we don't bury it. We still farm it back out to whoever it is, investigate stuff and make sure that we discuss it or make sure we take appropriate action, but we just don't go through this Title IX process. So if you get a written formal complaint where a student says, well, yeah, during class, the kid sitting next to me for the past week has been using racial slurs to me or calling me really, really bad names that are related to race or something else. Well, in that particular instance, we look at the formal complaint and say, well, no, that's not quid pro quo harassment because there's no employee who's offering some sort of benefit based on participation in a sexual act. There's no hostile environment caused or created by some sort of sexual attribute or something like that. And we don't have the dating violence, the stalking, the sexual assault, or the domestic violence. And so in that instance, we would kick that complaint out for Title IX and say, no, this is more of a racial discrimination complaint, and so we're not going to follow Title IX. Title VII coordinator, whoever you have who handles that stuff for your kids, congratulations, here's a new report for you, and we're going to handle it that way. And the same thing, we look at it. Did the allegation or does the information in the formal complaint show that this particular conduct occurred during a school activity or a school program? Or is it a situation where, again, we had students who were off at a charity, or not a charity, but they may be on the same youth soccer team or whatever in the community. And there's the allegation that a locker room one day or at a practice on a Saturday, my classmate, we're both on the same team, and my classmate started touching me in private areas during that particular practice or in the locker room or whatever. Well, that would be conduct that, if true, would meet the definition of sexual harassment because we have this hostile environment for the physical touching in inappropriate areas. But that occurred outside of school activities, and so that would not be something we would discuss under Title IX. And the same deal if something happened outside the United States, which we talked about earlier. So if we look at that complaint and we can say no to any of these things, again, no, this conduct doesn't meet the definition of sexual harassment, it didn't occur in our school programs, or it didn't occur in the United States, we dismiss the complaint for purposes of Title IX, and we kick it off to somebody else to go ahead and investigate and review. There are also some discretionary dismissals or scenarios where we have the flexibility to dismiss a complaint. Those would be circumstances where if we start the formal complaint process and then the complainant down the line sends something in writing to the Title IX coordinator saying, no, this is too much, I don't do this anymore, I don't feel like going this route anymore. And so if the complainant withdraws that complaint in writing or tells our Title IX coordinator they don't want to proceed anymore, we can dismiss the formal complaint at that point. We can also have the discretion to dismiss a formal complaint if the respondent, again, the person who is alleged to be the harasser, if that person is either no longer employed by the school or if they are no longer enrolled in our school. We've seen that happen quite often where maybe there's an allegation. A couple examples I've heard where there's a coach who has been touching students inappropriately, potentially. We give the coach notice of what's going on, and they probably see the writing on the wall, and they say, peace out, I'm resigning, I'm out of here, that kind of stuff. Or the same deal, if we have students alleged to be doing something, and we notify the parents, and the parent of the person who's accused of the harassment says, again, peace out, I'm out of here, I'm withdrawing my child, I'm going somewhere else. Well, in those circumstances, we no longer have any sort of disciplinary authority over those respondents because if they resign, we can't fire them again after they resign. We can't put a corrective action plan in place. If they're withdrawn from school, we can't expel them again, or I guess we could proceed with an expulsion hearing potentially, but we can't do anything else against them disciplinary-wise. And so the regulations give us the flexibility to stop that complaint process at that time rather than going through this huge, thorough investigation process. Or finally, we also have the discretion to dismiss if there are specific circumstances that will impede our ability to complete an investigation. I'm not 100% sure what that's going to be, but I think for the most part that could be maybe we have a complaint filed or maybe our coordinator files a complaint over the complainant's wishes, the complainant doesn't want to participate, and so we start the investigation and the complainant won't talk to us, the respondent won't talk to us, there's no witnesses, and we just simply can't make a decision because we can't gather any facts. Well, if no witnesses will talk to us and no parties will talk to us, that would really hamper our ability to go ahead and do an investigation. And so we could document that and be able to potentially dismiss the complaint in those scenarios. So again, this last one, I don't think I've ever seen it happen, but there is some flexibility. If there's just some reason we simply can't do an investigation, we could think about dismissing the complaint there. And I guess I should also mention that anytime we dismiss a complaint, whether it's a mandatory dismissal or a discretionary dismissal, we always have to give written notice to both parties that the complaint is being dismissed and give them notice of the reasons why we're dismissing. And then there's also some appeal rights that will attach to the parties if they want to try and challenge that dismissal. Okay, so we've gone through that. We've got our formal complaint. We've decided that yes, we can say yes to the questions about conduct meets definition of harassment. It occurred in our program or activity at the school, and it happened in the United States. We then get to send out more letters. You'll see that the Title IX process is very much sending lots of letters and lots of notices to the parties. Once we've accepted that formal complaint, we then need to give written notice to both the complainant and the respondent that essentially confirms that, yes, we have received this complaint. These are the allegations that were included in that complaint, and so we essentially copy and paste whatever it was that the complaint included in the form, and we notify or we identify the parties that were involved. And so again, this is something that's different than our normal investigations. Normally, if we have a report that, Alan did something to Jimmy or whatever the case may be, yeah, we may tell the parents that we're investigating, but we don't necessarily say or tell Jimmy's parents that Alan is the one who maybe did something or whatever. We usually don't share that information. But under Title IX, again, open book, we need to let both parties know who is involved. And so the complainant's going to know who the respondent is, of course, because the complainant's the person who actually identifies what happened, but then the respondent is also going to know the identity of the person who's making the complaint against them. And that's going to apply regardless of whether the complainant and respondent are students or adults as employees. And so that information is always going to be shared. Realize that can be a bit hard sometimes because maybe we have a feeling that there's a threat of physical harm or maybe somebody's going to go crazy and retaliate. Unfortunately, we're kind of stuck under Title IX. We have to do an open book. And so the parties are going to know the identities of everybody involved in this. As I mentioned, we also give that summary of the allegations of the report of what harassing conduct allegedly occurred, and just give as many details as we can about that. What happened, when it happened, where it happened, all that kind of fun stuff. We also need to let the parties know, especially the respondent, that we do have a presumption that the respondent is not responsible just because a complaint was filed. So again, we haven't made up our minds. It's not just, okay, we received a report and we automatically assume that the respondent did something wrong. We do have to have that presumption of, it's not a presumption of innocence because it's not criminal, that's basically what it is. Like it's presumption that the respondent is not responsible automatically. We have to let the parties know that they can have an advisor of their choice. That does not need to be an attorney. It can be anyone, can be an advisor to a party. That advisor has the opportunity to receive information or see the evidence that's been collected by the school, but the advisor does not have the opportunity to actually, if they attend an interview of somebody, they don't get to start asking questions or things like that. They are there as an observer, and then once the school has finished its stuff, they can advise the person they're working with as far as what their next steps may be. But again, advisor does not mean someone who comes in and takes over the investigation or starts asking a bunch of questions of different people, things like that. They are there to advise the person they're working with. And then we also need to be sure that we let folks know that we have policies in place that essentially tell them, be honest. You shouldn't be making this stuff up. This is serious. If you are knowingly making false allegations, providing false information to us during the investigation, we can follow our code of conduct for you being less than honest. So we just want to make sure they understand that we do expect them to be honest and forthcoming with this so that we're able to do a thorough and appropriate investigation. Okay. Our Title IX coordinator then gets to assign an investigator. The Title IX coordinator can be an investigator, so there can be a dual role there. Or we can have kind of a pool of people who can be designated as investigators to actually look into the complaint and start gathering evidence. The regulations are very clear, though, that when it comes to our coordinator or our investigator, our decision maker, or anybody in our appeals process, those individuals do need to be trained. It's a very lengthy training. The section that talks about what they need to be trained on is very, very, very long in the regulations. The trainings take probably about 3 hours or so to get through. So it's a very intensive thing, much more intensive than what we're doing here. So we need to make sure that our coordinators trained, investigators trained, and other stakeholders are trained. But again, that's kind of flexibility or something that y'all can do at a local decision, who you have, if you want to have a pool of people that can be investigators, or if your Title IX coordinator just kind of gets the short straw and ends up being the investigator in all circumstances. Once more, that's kind of something that's up to y'all as a local decision. We usually advise to have a pool in some ways, just because the regulations also make clear that anybody involved in this process has to be clear or free of any conflict of interest or bias. So if it's a situation where you feel like a particular investigator simply couldn't be fair, maybe because their child is one of the people that's being accused of being a harasser, or maybe your child is the victim of the harassment. Well, it's probably not going to be fair for you to be the one investigating that or making a decision because there's an obvious bias and conflict there. So it's usually best to have at least a pool of a handful of people who can be an investigator, just in the case or in the event that there is some sort of conflict or bias involved, so that we can do an impartial or fair investigation. Sorry, I've got the barbecue mouth right now where it's my brain isn't quite working with that. All right. And if you happen to be an investigator, but you're not the coordinator, of course, you should always realize that if someone comes to you and reports sexual harassment, you don't jump right in and start investigating. We need to forward that or shepherd it through the Title IX coordinator, and then the coordinator makes that assignment as far as who it is that's going to be the investigator. As we talked about with the student code of conduct earlier, if we have an investigator, that needs to be somebody who actually knows what our Title IX policy is, needs to know what our investigation process is, needs to know what our policies are, handbook provisions, all that kind of fun stuff. And so it needs to be someone who understands what's going on, somebody once more that we're going to trust to be able to do a full and a complete investigation to the greatest extent possible. Just like as with our other disciplinary investigations, that person needs to know what type of evidence are we looking for. Is the report that a coworker during lunch keeps sending pictures of intimate areas to their colleague, or things like that? So is it, well, are we going to have to ask for text messages or ask for copies of instant messages? Or are there social media postings that are going on? So again, we'll have to identify that. Or there's the allegation that in the cafeteria, somebody touched me in a private area. Do we have security cameras there? That kind of stuff. So once more, we are looking for someone who knows what type of evidence to gather and what to look for. Or asking, are there emails back and forth where somebody's soliciting something inappropriate in an email, or those type of things, or sending dirty jokes, whatever the case may be. Know what you need to look for as far as evidence goes. Know the witnesses, be able to identify who those witnesses are. Once you start meeting with people, our investigators should always just kind of reassure them of their rights, do a brief walkthrough of this is what the process looks like. We have anti-retaliation provisions in place, and so we can't retaliate against people just because they're being interviewed or because they bring complaints to our attention or things like that. Just assure people that, hey, we're here to investigate and gather information about this particular report. We should not, our investigators, when meeting with people, do not promise a complainant or someone else that disciplinary action will be taken. We don't know if there's going to be disciplinary action until the investigation is done and until our decision maker has made a determination regarding responsibility. So never start a complaint off or an investigation off by promising we're going to get Alan and he's going to get fired. No, we can't say that until we've completed the investigation. And also, please never, ever ensure or promise confidentiality. We know we simply cannot do that, especially in circumstances where if there's a report that perhaps a staff member has touched a student in an inappropriate area, well, we can't ensure confidentiality because we have our legal obligation under Chapter 261 of the Family Code to make a report to DFPS. And so we can never tell someone, whatever you say in this room, stay here. It's not a whatever happens in Vegas stays in Vegas situation. That is not appropriate for Title IX. So please never, ever promise confidentiality. We simply cannot do that. And then also as the investigator, you need to remember your role or kind of know your role. You are there to investigate and gather facts. The investigator is never going to be the person who actually makes a decision as to whether harassment occurred or not. That is going to be somebody else down the line. Your obligation as an investigator is to gather the facts. That's it. So that is what you are there to do as the investigator. Okay. I've already talked about this several times in other slides and other presentations, but again, make sure we get evidence. Are there emails? Are there pictures? Are there text messages? Is there security footage? Do we have letters? If there's an allegation that a particular event occurred on June 14th, is that today? Whatever today is. There's an allegation that happened on June 14th. Well, do we have absence logs? Can we show that that particular individual who's accused of harassment, were they even at school that day? Or were they out for a sick day? Or were they out on vacation? Things like that. So we need to be able to identify and gather all the records that we can, all the information that we can to make sure that we can get as many facts as we can to see what was going on. They're also, going kind of back to the DFPS reports, or perhaps we need to make a report to law enforcement because there's an allegation that an adult has done something inappropriate to a minor. We realize that we as educators, y'all are not trained forensic investigators, especially not when it comes to questioning children about possible abuse or neglect. So if DFPS or if the police tell you, hold off, you need to slow down a little bit, let us handle this first, please listen to them and comply with that. We don't want to put you in a situation where you go around and start asking a bunch of questions and somehow jeopardize the police or jeopardize an investigation by DFPS. If that circumstance applies or that comes into play, we would just let the parties know that we are holding off, we're kind of pausing this Title IX investigation or the formal complaint process because we've been directed by law enforcement or by DFPS to slow down. So just considerations there. If situations where we got potential actual sexual assaults or perhaps there's child pornography issues, things like that, we're normally going to hold off at least until DFPS or the police give us the okay after we've made those calls to law enforcement authorities. Okay. When it comes to potential sexual activity, there are some rape shield protections in Title IX where generally we're not going to start asking complainants for their complete sexual history. Like, tell me who all your partners. Well, no, that's not relevant. So we're not going to turn this into official. And I know y'all don't want to know. Like, you don't want to ask those questions. I know you don't want to know. But the regulations have just made clear that we're not going to start questioning people about their prior sexual histories or what they may or may not have done with different individuals. However, there are two exceptions to that. If there is an allegation of possible non-consensual sexual activity, we can ask about sexual history if the respondent is saying, well, no, I'm not the person who did that, but that particular person, it was somebody else who was engaged in sexual conduct with that person. And so we could ask questions, was it the respondent or was it somebody else? That type of stuff. Or if there's a defense raised of possible consent. If the respondent says, well, yes, we engaged in that particular sexual activity, that contact, but it was consensual. We can then ask limited questions to see if consent was an issue. This is something that's really a holdover. Title IX, for the most part, this investigative process was something put into place initially for higher education, for colleges, things like that. But Department of Ed, in its infinite wisdom, decided to cascade that down all the way through K through 12 schools. And so we essentially follow the same process that higher ed does. I know that these particular questions, for the most part, hopefully we never have to ask them when it comes to kids, but just be aware that, again, normally you don't want to ask those questions, and for the most part, you can't ask those questions about prior sexual histories when we're doing a Title IX investigation. So I just needed to mention that. All right, when we're investigating, when we're setting up interviews, we need to give prior written notice to the parties or to the person being interviewed. We can't just have the investigator walk into class and say, hey, Alan, come here, we're going to come talk right now. No, we need to give them sufficient notice beforehand so they can actually prepare and be ready for it. And so there's no set time for what that is, but we figure, hey, give it at least 48 hours notice. So, again, I mentioned Title IX, the process full of letters. This is another letter that we have where we just give it to the party, whoever it is we're talking to, and say, congratulations, in 2 or 3 days, we're going to meet at this particular time and we're going to talk about this complaint of possible sexual harassment. It's also very important that we actually interview everybody, or at least talk to all potential witnesses. Once more, if we have somebody who says, hey, there were 5 other people in the room that this happened, well, we should probably do our best to talk to all 5 of those people and not just ignore them or only talk to one. If we only talk to one, we better have some really good reasons for why it is that we can't talk to the other 4. Maybe they've all of a sudden disappeared to Costa Rica and are living life on a beach, whatever, that kind of stuff. And so if they just disappear and are gone, well, we're not the police. We're not going to show up at people's doorsteps and say, hey, we're here to talk about Title IX. We're not required to do that. But if we have the capability to talk to somebody who's a potential witness, we need to make sure we do that. And if we don't talk to them, we better have some very solid documentation or reasoning justifying why we did not speak to them. And then also realize that there may be circumstances where you talk to somebody and think, okay, I'm done with that witness, but then you talk to another person or two and realize, oh, I need to go back and follow up and ask some more questions of this person. So again, this investigation process is very fluid, and we need to be able to kind of roll with whatever we need to do and go back and do as many interviews as required to complete our investigation. Throughout this process, we need to remember that the school is the one that carries the burden of proof on this necessarily, the burden of gathering evidence. It's our obligation to ask questions. It's our obligation to ask for documents or find documents, things like that. So we have that burden of gathering evidence. And of course, we need to be sure that we are giving both the complainant and the respondent equal chance to participate in this process. And so if we say we're going to talk to the complainants, but we're not going to talk to the respondent, well, that's not appropriate because both of the parties should be given the opportunity to share their side of the story Or if we say, we're only going to accept emails from the respondent, but complainant, we're not going to take anything you give us. Well, we can't say that either. Once more, both parties have the chance to share their side of the story, and that includes giving us emails, giving us texts, giving us whatever it is that they may have. Interviews, I'm not going to spend a lot of time on this because you all know how to interview people, but normally in this process, we'll start with the complainant, the person who was possibly harassed, just because that's going to be the person that gives us the most detail about what potentially happened. Then we go to our witnesses, and then once we feel, or our investigator feels like they have a good feel for what may have happened, we'll usually talk with the respondent last. Again, just because at that particular point, we feel like we've got most of the information, and then we can ask more appropriate questions based on what everyone else has told us. But again, there's no legal order for when people should be talked to, but for the most part, start with the complainant, do witnesses, and then end with the respondent. May need to go back and do follow-ups as time may be. It's always best to do these interviews in person. Again, usually you don't want to do it over the phone, maybe by Zoom in some circumstances, but for the most part, do it in person. Interview witnesses separately. We're not going to have 5 people in the room at the same time asking the questions. We want to be sure that they're not prejudicing each other or just trying to say what somebody else said or that kind of stuff. So interview people individually. It can certainly be appropriate especially if you're talking to a child, have another adult in the room there to be a witness to make sure that we have somebody there who can verify that, yeah, this is what happened and nothing weird went on during the interview, things like that. When you're getting ready for the interview, make sure you have that copy of the formal complaint so that you can check, okay, in this particular complaint, there are 4 different instances where they say harassment occurred. Well, we need to prepare a response or get evidence about each one of those 4 instances. We can't just focus on one. We need to be able to get evidence or get information about each particular complaint in there. So it is very important that you come prepared and that these are the issues I'm looking into, and make sure that you can check off each of those issues so there's nothing left hanging out there. Be sure that you have something where you can keep track of, these are all the people I need to talk to, and each time you talk to somebody, you can check them off the list, or every time you get a piece of paper or a document or something else, you can check off, here's the evidence that we have that goes along with this. Let's see, what else do we need to do? As you're talking to somebody, once again, explain that your role is to be an investigator. You are not there to make a decision. It is just your obligation or your role to gather information. I already mentioned don't promise confidentiality, don't do that kind of stuff. Explain to them, hey, here's our non-retaliation policy, and explain once more that we would appreciate if they were honest with us and just be as truthful as they can be. As you're sitting there interview, do not share your personal thoughts. If somebody says something, you don't just kind of point and start laughing or saying, you idiot, what are you doing? Like, no, we're not going to share your personal thoughts. That's not okay. You're there to be professional and to be a neutral gatherer of facts. Don't sit in there, agree and disagree and say, yes, you're right. We're not going to agree or disagree. Once more, you're neutral. You're there as a fact finder. And also, please prompt them as many times as you can. Is there anything else that you may know? Or are there any other people who might have information about this so that we can do our best to ensure we are getting what's out there? When it comes to speaking with the actual respondent, once more, we need to emphasize to that individual that we have not made up our mind, that again, we are just in the evidence gathering stage. And let the person know that, again, a decision will be forthcoming later, and we let them know the evidentiary standard that we use. I think pretty much everybody has adopted the preponderance of the evidence standard when it comes to Title IX, which is the same standard as we use in our disciplinary decisions. Is it more likely than not that conduct violating Title IX has occurred? And so just explain that is what that's not what we're looking for. We shouldn't phrase it that way, but say that is our standard, and that's the standard that will be used as we go throughout this process. Make sure that we document our interviews, document the time, the location, the date, all that kind of fun stuff. That's going to be important because when we put together our investigative report, we need to actually include all that information. So again, document when the interview took place, where it took place, who all was there in the room. And then as you are asking questions and getting responses, just document those in objective fashion. Please, when you're taking notes, don't turn it into your personal sketch pad or your doodle pad. That makes things look unprofessional. That's always a little bit, makes us scratch our heads when we see investigative notes that come in where we've got lots of clouds drawn or sunrises or sunsets. Or perhaps we have folks who are writing down little snarky comments like, oh, what an idiot, or this dude, can you believe what, I mean, we see those type of things. So please, when you're doing these investigation notes, keep it professional and stick to the facts. Just very much question, response, and don't editorialize and don't turn into your sketch pad or things like that. And then also when you are documenting stuff, don't write down that, yes, this is absolutely true, or yes, I believe this, things like that. Once more, that's not your role. You are there to simply gather information and gather facts. And please consider that your notes that you take or the information that you provide, that is going to be shared with both the complainant and the respondent, and it's also going to be shared with our decision maker down the line. And so you're going to have other people who are looking at these documents or seeing what it is that you're writing down or what you're putting down on paper. So just keep that in the back of your mind. Consider that these are not going to be private personal notes. Other people are going to see this, so keep it professional, keep it neutral, keep it objective. After the interviews, update everything, do your witness list, do your document list, whatever, all that kind of fun stuff, and get ready for the next person. Keep in mind that maybe you talk to one person and they bring something up, you're like, oh wait, now that I hear that, I may need to call the police or I may need to call DFPS. So remember that as you're going through the investigation. Even if a particular formal complaint form doesn't mention anything that would normally make us call the police or go to DFPS, if somebody brings something up in an interview, we may need to make those calls as you go throughout this process. And then be sure that if you start collecting evidence, if somebody brings you an email or brings you a letter or things like that, make sure that you keep those things secured and that they don't wander off. So you need to have your investigation folder, and we're going to want to make sure that folder stays, under lock and key or somewhere where it's not just readily available to everybody in the office, things like that. So keep track of those things as well. All right, so after we've done our interviews, we've collected all of our documentary evidence. Excuse me one second. At that particular point, once we think we've done all of our steps necessary for the investigation, our investigator is going to be creating this evidentiary packet or kind of an appendix of evidence that will include the witness statements, that will include emails, texts, whatever it is that we have. And that particular evidentiary packet is then going to be shared with both the complainant and the respondent. The Title IX process is not fun for schools because it takes a really long time. It can take 45 to 60 days for these investigations to be done. I know that sounds like a long time, and it is a long time, but there are a lot of periods during that time frame that are kind of dead periods for us. And this investigation packet, that is one of those dead periods, because we have to give both parties at least 10 days to review and consider that evidence. And so we do our investigations, we get our packets ready, we send those evidence packets out, and then we essentially sit and wait for 10 days. We can't proceed during the investigation during that time period. We give time for the parties to review that evidence, and then they also have an opportunity to submit anything extra. If they think we missed something, they can go ahead and send us another email or another text, whatever it is, and then we just go ahead and add that to our evidence packet. So out of our investigation process timeline or whatever, 10 days is eaten up as this opportunity for the parties to review the evidence. And as I mentioned, this is open book, so we are not redacting. We're not taking out people's names for the most part. Both parties have the right to be able to see that information and know where this information is coming from. So very much different than our normal investigations. This is going to be very much open book. After that 10-day period is over, that is when our investigator can finally prepare an investigative report or issue an investigative report. That is going to be a very detailed summary. Include summaries of the allegations in the formal complaint. It's going to give information about the procedural steps that were taken. This is when parties provided notice of interviews. This is when the interviews were conducted. This is where they were conducted. This is who was there. So we're going to give all the procedural information. And then that investigative report is going to, I shouldn't use the phrase regurgitation, but it's simply going to regurgitate the evidence. And so we're going to provide a summary of what was gathered during our investigation. We're going to, again, summarize the evidence gathered. We're going to identify, here's the potential code of conduct, the potential policies that may have been violated by this. So we'll, copy and paste our Title IX policy, our anti-harassment stuff, all that kind of fun stuff. So it's very much just a summary of what was done during the investigation. Let's see. I already mentioned we need to include our investigation timeline. If there's any sort of, if it's taking us longer than we initially thought, we need to explain or identify those gaps, or not gaps, but identify those delays, explain why. Perhaps a complaint was received 3 weeks before winter break, and so you were closed for 2 weeks. Well, we know that you're not going to be interviewing people during winter break, and so you need more time because there's spring break, winter break, whatever it is. Or maybe the police told you to hold off for a while, so we explain that in these investigative reports. And then we include that evidence packet. So the information that was submitted to the parties that they had 10 days to review, that is also attached or included with our investigative report. Once more, this investigative report does not include any findings. It does not include any suggestions about whether or not harassment occurred. It is simply to say this is the evidence that was gathered during the investigation. So you are summarizing the evidence, not making conclusions. And please remember that once more, both parties, the complainant and the respondent, are both going to get copies of the exact same investigative report. And so hopefully you've done your homework and you remembered, okay, the complaint had 4 issues, and we have 4 issues in the investigative report, and we have facts to go along with each one of those 4 issues. So be sure that you didn't leave any holes or leave any matters unaddressed when it comes to claims of possible harassment. This investigative report is essentially a roadmap for the decision maker. That's what you should be thinking as you prepare it. Once that's done, the investigative report is completed and it is sent back to the parties, and they then have another 10-day period to go ahead and review that investigative report and submit potential comments, or if they feel like additional evidence needs to be gathered, they can ask for us to do that, and we have some obligations there. I won't get too much into that. But again, so this is an additional 10-day period where the parties can review. So we had 10 days to review the evidence packet, another 10 days to review the investigation report. So there's 20 days of dead time throughout this whole process. So hopefully you maybe see now why it takes so long, because there are literally 20 days where we can't proceed or do anything more because the parties have the rights to review things. The investigative report can go to the Title IX coordinator, and then our Title IX coordinator then assigns a decision maker. The decision maker has to be a fresh set of eyes. The Title IX coordinator cannot be the decision maker, and the investigator who handled that complaint cannot be the investigator. It needs to be somebody coming in with a completely fresh outlook, I guess, for lack of a better phrase. So somebody who had no prior involvement in the case. Our decision maker reviews that evidentiary packet or that investigative report, and then ultimately makes the decision as to whether or not, or whether we met the standard to show that harassment occurred. So again, that more likely than not, that preponderance standard, can we show, or does this evidence show that harassment did occur, or is there not enough there to allow us to reach that finding? Our decision maker then gets to write a written determination regarding responsibility, and that is another very long or most likely findings, where again, we are summarizing all the steps that happened beforehand, and then we are actually, walking people through, here's what the evidence was, here's my conclusion, and then tie the facts back into that. So again, if the allegation was that, on June 14th, Alan did something inappropriate. Well, if our evidence shows that on June 14th, Alan wasn't at school, Alan was at Region 10 presenting on Title IX. Well, that would be something that we would be putting in that report, that no, we don't think the evidence shows that harassment occurred because Alan wasn't there on that day, and so he couldn't have done that type of stuff. So it's not just issuing a finding and saying yes or no, it's issuing a finding of yes or no, and then also being able to explain why it is that we reached that conclusion. So that can be a rather lengthy report, and again, need to make sure that we hit each and every allegation or each and every incident in that formal complaint. If there are 4 allegations, we need to have conclusions for all 4 of those allegations. Otherwise, we've got holes in our report. That determination regarding responsibility also includes information on appeals. I'll talk about those here in a few seconds. I'm going to skip over that because I'm running over time. But anyway, that written determination, that's going to go to both parties at the same time. So it's not just we tell one party but not the other, or we wait 2 weeks to send it to somebody. We send it out the same day, essentially the same time to both parties. They get it. And then when it comes to appeals, there are 3 required grounds for appeal and kind of one if the school wants to accept appeals. If one of the parties says that there was a procedural irregularity that affected the outcome of the case. So again, perhaps we told you there were 5 witnesses, but you only talked to one person. Well, why did you only talk to one person? Things like that. So if they say that we messed up a procedure, or we did not talk to the complainant, or we did not talk to the respondent, that would be a procedural irregularity. That can be grounds for an appeal. If one of the parties says, well, hey, there's this new evidence that we didn't know about while the investigation was ongoing, That one doesn't come up too often, but again, maybe there was something that nobody knew about that they can then use, or they could potentially say this new evidence that we didn't know about before. You need to consider that, because if you would have considered this, the outcome may have been different. And so that new evidence they didn't know about before, that's a potential grounds for appeal. Or if someone claims that one of the Title IX stakeholders, so either the coordinator, the investigator, or the decision maker, had some sort of a bias or a conflict of interest of some sort. So again, my son is accused of being a harasser. Well, I should not be the person investigating, or I should not be the person making the decision. That type of stuff. So if somebody says there was a bias or a conflict that impacted the investigation process, that can be another grounds for appeal. Or there's a catch-all where if your school adopts a policy that says we will accept appeals for reasons X, Y, or Z, if we have identified those, that can be another allowable grounds for appeal. We then need to designate, if there's an appeal, have an appeal officer. That has to be yet another fresh set of eyes, so not the coordinator, not the investigator, not the decision maker. That's going to be a fourth person potentially who has no prior involvement in the case. They review what happened, they look at the record, they look at the investigative report, they look at the decision, they look at the arguments of the parties as far as why an appeal should or should not be granted, and then we make a decision from there. And then issue a written decision on that appeal explaining why it is that we're either going to uphold that determination regarding responsibility, or if we're going to perhaps kick it back down for more investigation or things like that. All right, so that's Title IX in a nutshell. I know that's a lot there. Any questions on just that so far? Again, all this is subject to change in the somewhat near future if Department of Ed ever actually issues their final rules. But it is a lot. It's a lot to do for sure. So thank you all very much.